So I'm going to inquire if Archangelo can hear me. Are we having any other issues, or are we about to go live? Thank you everyone for your patience. Some access to the hearing. So sometimes it takes a little bit of finessing.
We're good.
We're good. We're live now. All right. Well, let me introduce myself and the panel to you. My name is ADRIENNE Vuono. I'm joined today with Justice Greg Massing and Justice Kenneth Desmond. Welcome to today's sitting of the Appeals Court. Just a quick reminder that you each have 15 minutes to present your argument, and there is no rebuttal in the Appeals Court. I'm not going to ask you to be patient again, because you already have been patient with us this morning with some issues, and let's just hope that we don't have any more. So I'm going to call the case officially now. Commonwealth versus Domingo Palma, 2020-0597. And Attorney Combs, you may begin your argument.
Good morning. May it please the court. Thomas Combs for Domingo Palma. This case presents, in many ways, a very unusual error. I think it's unusual in two primary ways. First is really the extreme prejudice that was visited upon this case by the non-responsive testimony from the government's first complaint witness. It alluded to weapons ownership, to threats, speculative threats with a gun, potential racial motivation for ownership of that gun in the first place. Really kind of an extraordinarily, inadmissible, but really an extraordinarily prejudicial piece of testimony. The second thing that's unusual is how it came about. It's not easily ascribable to any party except really the witness herself. By her actions, she seemed intent upon injecting this sort of testimony or prejudicing the defendant in some particular way, despite not only the actions of defense counsel in filing a motion limine to keep not just general prior bad acts, but this specific unfounded allegation out of the case, the government's agreements with that motion, and then ultimately the court allowing that motion by agreement of all the parties. It seems there was no question that the evidence was not admissible for any legitimate purpose. I think we can
agree, just speaking for myself, I think we can agree that we have a rebellious witness here. Clearly the witness was instructed by the prosecutor not to talk about this. And there seems to be, if I'm right on the record, no question that instruction was given, and it was given sufficiently. I think the prosecutor mentioned it a couple of times during the course of the trial. Would you agree with that?
I would agree that there's a few mentions of the prosecutor instructing the witness in accordance with the court's order. So I would agree, and that's again why I think it's really an unusual kind of error, because not only
would you also agree that folks were somewhat on notice that this might potentially be an unwieldy witness?
The government does make mention of that. Now, that raises another interesting question on its own. I mean, first, the idea of having a motion limine, of frankly the defendant taking particular care with filing that motion to alert the court beforehand that this is a potential issue, receiving that order from the court conveyed to the witness, is really the defendant doing everything that he can to make sure that testimony does not come in. I mean, there is incumbent upon everybody, not just the defendant and the prosecutor, who again apparently conveyed that order from the court to the witness. I think that makes the error much worse in a sense, because the witness, knowing that this testimony was not supposed to come in, testified in direct contravention to that order, to testimony that was highly prejudicial.
Well, of course, it didn't come in on direct, right?
Correct.
She'd gone through the whole direct examination without doing that.
That's correct. And again, that's sorry, go ahead.
You've been very agreeable to our questions so far. I got one more for you. Would you also agree that really the only issue before us is whether the judge abused his discretion in denying a mistrial?
I preserve two claims here. One is prejudicial error. One, as Your Honor just said, is the abuse of discretion for denying the motion for mistrial. The reason I am arguing both of those is I think that the moment when the testimony is it's messy, sure, but it's objected to, frankly, forcefully right in the moment that it occurs. The initial motion is one for a mistrial, but my reading of the Williams case and of Rule 22 is that, in that moment, the error is brought to the court's attention in no uncertain terms. So it's not only
the court struck it. The court immediately said, this is struck, disregard it.
Right. And that gets into a rather thorny issue of what defense counsel had as far as options in that moment. Because remember that this testimony, and this speaks to Justice Desmond's question as well, this testimony was entirely non-responsive. A yes or no question was asked about a different topic, and the witness essentially answered with whatever she felt like saying. So this is a surprise, to say the least, when not just is it non-responsive, but this testimony was ordered to be kept out of the case. So then defense counsel, does what he can.
Be that as it may, it was clear that nobody expected to hear this, except for the fact that even through direct, this witness was very difficult to handle. Let's put that way. She was not an easy witness, did not answer many questions directly. Could have been problematic because the use of the interpreter, I don't know. But the issue is that once, as Justice Massing's pointed out, the testimony was struck, why can't we rely on that as to show that the error was any potential error was cured, and the jury was told to disregard that evidence, and the jury is expected to follow the judge's rulings.
Because
just stopping it right there before we go on to what defense counsel then solicited. At that point, that's when the judge denied the mistrial. Judge struck the testimony, denied the motion for a mistrial. So right at that point, why is it that you say that the mistrial should have been granted?
Because there are certain errors that are so inflammatory, so uncurable, that an instruction cannot do anything. It is the proverbial bell that cannot be unrung. That's why I cited to the Niemiec case, to Redmond. I mean, there's a lot of sites in there where the SJC and this court have both said that there are errors that are so serious that can infect the trial so substantially that instruction essentially cannot cure that error. And that's exactly what defense counsel in this case is faced with. And it's he says he's between.
Is he though? I mean, we're talking about a firearm in a sexual assault case. We're not talking about a prior rape or prior sexual assault case. So wasn't that a strategic decision by the defense attorney to elicit more about the firearm and make it a bigger deal than it may have been?
Right. Well, that's true. And that's sort of step two here. But to speak to the initial question as to whether or not it can be cured, I understand that, the government, the Commonwealth, characterizes it as collateral. It's a collateral issue. Well, that's true, but that's the problem with prior bad acts and with propensity type testimony, is it's a collateral issue that distracts the jury, that potentially, it conveys that the defendant is someone with a propensity towards criminality. And that's the specific thing that is never cured in this case. So I think defense counsel is facing one of two strategic decisions. One, the decision that he ultimately goes with is to try to ameliorate the error by further cross-examination. Frankly, another is to just hope and pray that the jury can be cured by simply a motion to strike or some sort of curative. But again, whether it's the Niemiec case, which is just a couple of years ago, Redmond, any of the cases I listed, there are certain errors, and I strongly believe this is one of them, that cannot be cured just by a motion to strike, to say disregard. I mean, keep in mind also that one of the issues that was really a live one at this trial was why there was a delayed disclosure. In fact, the government thought it was important enough that they put on an expert to talk about why that might be. Now, this goes to that issue, so it's really not entirely collateral. But then it goes even further, and it talks about weapons. And Justice Desmond, you're right that it is sort of a separate issue. But as I state in my reply, raising the issue of weapons when it's not related, like a weapon that has nothing to do with the case that was being tried, that can be particularly prejudicial because there's obvious effects that flow from that, whether it's propensity or some other effect of a prior bad act.
Well, can I direct your attention to another part of this issue, which is the judge's final instruction to the jury. So first, of course, the judge did offer to give a curative instruction at that time. Strategically, defense counsel decides to take a different route and will solicit more information to undermine the victim's, the victim's mother's credibility. But at the end, the judge was pretty direct. Would you agree? That talked about, again, with the theme of having you agree with us, sorry about but would you agree that the judge went right to the heart of the matter and said, you know, the defendant has not been charged with a firearm offense. The defendant has not been charged with any kind of domestic assault. This is not something for you to consider. That was fairly specific.
I would agree that it's specific. It raises to me the larger issue of, you know, if I think that the language the judge uses or used in the instruction was those issues do not bear in the case that is in front of you. But the problem is he didn't, you know, the evidence wasn't excluded entirely. It's totally unclear as to why that evidence is there at all. And the judge did not give any kind of prior bad act instruction at the end of the case, which.
What do you think about it? What was somewhat clear, because defense counsel argued in his closing that, you know, that you couldn't believe this particular witness, for example, of what she says, and there's no evidence of it, right? So there was some, it was put in some perspective, let's put it that way. This evidence was put in some perspective by defense counsel.
That's true, but I don't see defense counsel as having really any choice at that point. The evidence came out that he did everything he could to keep out of this. And again, I credit him because he knew that this was, you know, we're talking about a witness that may give more information than is needed, but he did everything he could to make sure that this evidence didn't come in.
No, he was vigilant. He was vigilant.
And then when faced with it coming in, he had to make a choice at that point whether to try to mitigate it or just to rely on instruction. And he's absolutely right that in many cases, this being one of them, an instruction will not be sufficient because the evidence is so prejudicial. So he has to do what he can.
Reasonable minds might differ as to that point.
One moment, Justice
might differ, excuse me for interrupting, as to that singular point after the initial reference that was immediately struck. Whether or not more damage followed, reasonable minds might differ. Would you agree with that? I mean, a lot of the information that seems complained about now was elicited after the initial first reference.
Well, I'd push back on the use of the word elicited. The second, if Your Honor is referring to the testimony from the witness that the supposed possession of the gun was motivated by his fear of people of color, that was another answer that was wholly non-responsive to the question that was asked. I mean, well, I mean, at that point, the jury was excused. Both parties spoke to the judge again, and the defense counsel again said, "Judge, I cannot get a fair trial. The prejudice at this point is extreme." And then after the lunch break, the Commonwealth came back and said, "I'm asking you to deny this motion," or whatever phrasing it used. The effect was, "Deny the motion for mistrial. Do not mistry this case at this point." So this issue is going on, and I think of it not to use kind of a law school phrase, but the but-for cause here is the witness's insistence upon testifying in contravention to the order. So I have trouble, I guess, holding all of this against defense counsel, who is making decisions in the middle of a trial. This is not the easy decision to make because he did not ever think he would be confronted with this particular issue. So now he has to make a decision on the fly, whether it's trying to mitigate it through further cross-examination or trying to do what he can with it in the closing. I would not hold that against defense counsel somehow. Well, it doesn't matter. The error doesn't matter now because defense counsel took these specific efforts to try to mitigate it. I mean, listen, it's an unusual type of error, and I saw, you know, every individual that was involved in this case doing their best to try to remedy it. But what we're left with is something that, in my view, cannot be cured by instruction. It was not cured in this case, especially the instruction came in the final instructions, was not accompanied by any kind of language regarding the typical prior bad acts instruction to try to focus the jury on exactly how they could use this evidence. You know, a case I thought was really interesting as I was researching this, as I cited in my principal brief, is the case of Commonwealth versus Key from this court in 1985. It was a similar kind of issue. A prior bad act came out during trial when it shouldn't have, and the court was concerned because the evidence was kind of in there for an indeterminate purpose. The quote is, "This left the evidence in the case for the indefinite but prejudicial purpose for which it had been introduced." So I think that's what's occurred here is the instruction could not cure it, and it did not cure it in this case. I'm happy to answer any further questions. I know we've only got a minute left.
Yeah, no, thank you very much for your argument. I'll check with the panel and see if they have any questions. So Justice Massing or Justice Desmond, any additional questions? Nope,
No.
seeing none. Thank you very much for your argument. And now I'll turn over to the Assistant District Attorney. Attorney O'Sullivan.
Good morning, and may it please the court, Shane O'Sullivan for the Commonwealth. The non-responsive answer elicited on cross-examination from the victim's mother was immediately stricken by the trial judge upon a motion by defense counsel, and the judge then immediately held a sidebar conference. He offered to defense counsel the option of striking the testimony and offering a curative instruction as to that testimony. He solicited input as to the curative instruction that should be given. The trial judge dealt with this in the best manner possible, and in his discretion did not feel that this limited reference warranted a mistrial. That decision, the Commonwealth is asking you to uphold. One contrast I'd like to make from the defendant's brief: the defendant relies heavily, I would suggest, on the Roe case. And in that case, the judge did not do any of the things which the judge did in this case. The judge did not offer an immediate sidebar conference, did not solicit input as to a curative instruction, did not offer an option of a curative instruction. And the Roe case also dealt with a prior bad act that was the exact same conduct for which the defendant was on trial for. This conduct related to a collateral matter, related to not only collateral in the sense of it being a other act, but also collateral in what it pertained to. This testimony, as the trial judge noted, pertained largely to the relationship between the victim's mother and the defendant. To whatever extent it touched upon the delayed disclosure of the victim, the Commonwealth would submit that the jury heard firsthand from the victim the reasons for her delayed disclosure, which were wholly different and independent from whatever reason the victim's mother gave. The Commonwealth would suggest that the jury likely would have not credited this information for the delayed disclosure when they heard directly from the victim her own reasons.
Ask you, Attorney O'Sullivan, what, if you take away the this whole exchange, what, if anything, did the mother's testimony add to the case?
Your Honor, quite frankly, the only thing the Commonwealth would suggest this testimony added to the, or you mean as a whole or the improper testimony? I'm sorry.
No, her proper testimony.
So I suppose she did provide some background as to the relationship, which I would also suggest was cumulative of a lot of other witnesses. The other reason, the main purpose why she was called was as the first complaint witness. And I would like to comment on that briefly. In sexual assault cases, sometimes the first complaint witness can be a very important witness. In many times, the first complaint witness can be an important witness. In this case, however, I would ask the court to look at that first complaint testimony. It was consistent with the victim's report to the extent of the timing of it. There was testimony as to this phone call that was listened in on, a phone call between the victim and the defendant that the mother and the victim's brother listened in on. And the mother's testimony is consistent with the victim's that the first complaint happened at the conclusion of that phone call. However, the Commonwealth would concede that many of the other details, or some of the other details around that first complaint, who initiated the phone call, the exact details of the disclosure, are somewhat different. So I don't believe that the mother's testimony as a first complaint witness was so impactful because it corroborated some, but not all of the details. Where the overwhelming evidence came in this case from the Commonwealth's perspective is the corroboration not in the first complaint witness, but from the corroboration that occurred from all of the other witnesses, and I think most importantly, some of the forensic evidence taken from the defendant's cell phone. The defendant kissing the victim on the mouth was corroborated by her brother, who's Jose, who she had disclosed that to, and who had experienced a similar conduct by the defendant. The victim's testimony that the defendant had kissed her with an open mouth and forced her to kiss him on the nipples was corroborated by the thumbnail photographs that were taken from his cell phone. The victim's other older brother observed the defendant in the victim's bedroom in the morning and at night, corroborating the victim's testimony that that's when the abuse had occurred. And the voicemail that was recovered from the defendant's cell phone, where the victim left her what can be characterized as an inappropriate message for an 11-year-old, corroborated the victim's testimony that the defendant requested that she leave such messages. Her other younger brother also listened in on that phone conversation, that the inappropriate phone conversation between the victim and the defendant. So there was very little that this witness offered that was independent of other witnesses and that was impactful in light of the entirety of the case. And to whatever extent the improper testimony that came out on cross-examination, again, that went to a largely a completely collateral matter. It was, to whatever extent it had bearing on the delayed disclosure, it was contradicted by the victim herself. The prosecutor did not capitalize on this in closing argument. In fact, the prosecutor requested that the jury completely take it out of their mind. And it was mitigated by an instruction. The trial judge's instruction, which he solicited input on and did not receive a contrary instruction from the defendant or a request that the instruction be given at a different time, asked the jury to not concern themselves and that it did not bear on the ultimate issue. The defendant draws attention to the fact that the jury was not instructed as to the proper use of this testimony. And in most prior bad act cases, the jury is instructed as to the proper use of the testimony. What's unique about this case is this is not a prior bad act that the Commonwealth was intending to elicit for any purpose. So an instruction as to
there's no proper use of that testimony.
Correct. So the trial judge's instruction was completely appropriate. There was no instruction that he could give on proper use that would have been acceptable in this circumstance. The instruction he gave was to withdraw the issue from the jury's consideration for whatever purpose the Commonwealth might use it for. So in that regard, I believe the instruction was proper and appropriate. And I also would suggest that the trial judge's instruction went even further by instructing the jurors that no such charges had been brought against the defendant. It, in essence, bolstered the defendant's argument that this witness was not credible. So for all those reasons, the Commonwealth suggests that prejudicial error did not occur here, that the judge clearly did not abuse the wide discretion that he was in the best position to make as to whether this impacted the trial so that a mistrial was necessary. If there are any further questions, I'm happy to answer them.
Okay, just a moment. I'll check with the panel to see if they have anything else they want you to comment on. Justice Massing, no. Justice Desmond, no. All right, so we have no further questions. I want to thank you both very much. I think that your arguments were very helpful in this case. It's a tricky issue. It did come up in an unusual way, and we appreciate you.
All right, we are live.
Okay, thank you very much. All right, so good morning and welcome to today's remote sitting of the Appeals Court. My name is ADRIENNE Vuono. I'm joined today by Justices Gregory Massing and Justice Kenneth Desmond. Just a reminder, you each have 15 minutes to present your argument and there is no rebuttal. we thank you for your patience this morning. Thus far, we've had a few issues and we think they're all resolved. And if we do have any recurring issues, we ask you for your patience in advance. I'm going to call the case Cold Spring Green versus East Boston Savings Bank, 2020-0522. Attorney Gillerman, excuse me. Please begin your argument.
Good morning. Good morning. May it please the court. My name is Michael Gillerman on behalf of East Boston Savings Bank, which I'll refer to as the bank. This is a case on appeal before you involving one claim, a 93A claim, where all other claims of Cold Spring Green have failed below. It involves one bare conclusion, which is contrary to the underlying facts, including facts clearly established in the record. And it involves, is supported by only one sentence, which sentence cites to nothing in the record, and let alone provides the essential grounds for a decision. The bank makes three arguments this morning. Those arguments are: one, the derivative rule. I'll explain these arguments in more detail in just a minute. One is the derivative rule. Two is the appropriate appellate fact-finding rule. And three is the appropriate trial court fact-finding rule. And just to give you a little more details on these three arguments before I go into them in some depth, the derivative rule says that where a 93A claim is derivative of other common law failed claims, the 93A claim also must fail. The appropriate appellate fact-finding rule says that where the 93A claim is contrary to the documentary evidence below and the clearly established facts below, the appeals court can make its own findings of fact and reverse the 93A decision. The third argument, the appropriate trial court fact-finding rule, says that where the trial court failed to provide the essential grounds of its decision and engaged in a bare or ultimate conclusion, the case must be must be remanded for more fact-finding. So the first argument is the derivative rule. And the derivative rule works like this. Again, it says that where the 93A claim is derivative of only failed claims, the 93A claim must also fail. The point of the derivative rule is for a court to police against unmeritorious piling on of 93A claims, unmeritorious piling on. We all know.
I'm going to interrupt you. I think we understand the rule. The problem is the factual basis. And the plaintiff argues that there was evidence that there was a different conduct that was the 93A. It wasn't a breach of a contract. The jury found there was no breach of contract. It wasn't fraud in the inducement of the contract. It was this conduct of, to use the word they would characterize as extorting extensions from their client, which was different from any of those and didn't derive from any of those claims.
Well, Your Honor, the answer is pretty simple to that. If you look at their brief, which is at page 38 to 41, which sets forth what their argument on this point, they don't set forth anything there. There are no facts set forth there as to what this separate and distinct claim is. What they do say is that it is a separate and distinct claim. They do say the focus was not on the prior contract. They don't set forth what you just said. They don't do that.
But where did I get it from? I promise you, I did not read the entire transcript.
What you get it from is they cite to a case called Renovator Supply versus Sovereign Bank. That's the case they cite to. This isn't Renovator Supply versus Sovereign Bank. So they don't even argue that. But let's take a look and see if this separate extortion.
Are you saying, can I interrupt for a second? Are you saying then that the issue here really is that the under the rules of appellate procedure, they haven't made a sufficient argument on appeal, and so their appeal should be dismissed on that claim?
Yes. If you look at page 38 to 41, there's nothing there about what actually is a separate and distinct claim. It's not there. They make statements as to it is separate and distinct. They don't say how it is separate and distinct. They don't. Their obligation is to show that there is something separate and distinct. But let me take the Judge Messing's argument, his point, if I could, and answer his question. Mm-hmm. They say there's some kind of a separate extortion. Well, okay, take a look at what they say are their common law claims, and they are set forth in their second amended complaint, which is in the record at Roman numeral 1, page 13. Their claims for breach of contract, the commitment letter, the loan modifications, and their claims of false representation. They're all there. It's a full spectrum, all there in their common law claims. There's nothing they omit. Extortion, loan modifications, you name it, it's all there.
Can I ask you just a few? Can I ask just a few factual questions? Do you agree? They say in their brief that Dr. Ashkori paid $660,000 for the 4 extensions. Is that true?
Yes, he paid $24,000 for extension fees, and he paid over $600,000 in pay downs. That is true.
Okay, and I'm just out of curiosity. I mean, I'm going to ask you to speculate if you can. Where did the jury get $1,040,000 from?
We don't know, Your Honor. That's not stated in the record anywhere. It looks like it's an award of the second phase. It looks like it's a decision by the. It looks like it's the second phase plus some interest, but we can't be sure about that. We're speculating. But
Thank you.
But further, going back to your.
And
yes,
I'm sorry, just a few more. The just baseline stuff. This was the jury had given 93A advisory verdict. They didn't know it was advisory, right? For all they knew, they were actually giving a verdict.
I don't know if they were instructed if it was advisory. The judge clearly told the parties that it was advisory and that all aspects of the 93A claim would be reserved to him. I don't know if the jury was told that.
After the instruction, there's something like one of the counsel says, "You didn't say it was advisory, Judge," and then it's sort of like it was sort of a very curtailed discussion. But the jury was not told that this is just advisory.
I don't know that, but the judge clearly did say, and this is at page 6 of the appellee's brief. The judge clearly did say, and it's at Roman numeral 1, 1610 of the appendix, clearly said the jury verdict will be advisory and I shall reserve the entire 93A claim to myself. That's undisputed.
Right.
Okay, but my point here on this derivative claim is that their underlying claims for contract, unjust enrichment, and misrepresentation was full spectrum and included everything. And again, you can see that at their complaint, which is at Roman numeral 1, page 13, their various counts. There's nothing they don't include in their underlying claims. They lost them all. So what they must show is something separate and distinct and meritorious. Meritorious. If you look at one of the cases we cited, which is Northside Recycling versus City of Salem, Northside Recycling versus City of Salem, the appeals court there said that the appellee, or the appellant in that case, which was Northside Recycling, argued, apart from the other claims they'd lost, they argued that the City of Salem had engaged in repeated promises. But the appeals court said even that rhetorically distinct argument wasn't enough. The repeated promises were, one, neither enforceable nor reliance upon them was reasonable. So here, there's nothing separate and distinct that they show us in their brief, that they argued below, and they can't show us that it is separately enforceable. So the point is that, as I started out with, the feature of the derivative rule, which is to prevent unmeritorious piling on, should apply here. There's nothing shown here.
Weren't there other facts that did not go, as Justice Massing has pointed out, to the derivative claims? The fact that the bank was faltering financially, the fact that there's some testimony that the bank was not supposed to make any more lending decisions for residential projects or what have you. The fact that 2 of the managers who were negotiating ended up being terminated. The fact that they had done an appraisal and didn't offer that information to Dr. Ashkori upon his request. All of those things cumulatively, doesn't that support the 93A finding?
Respectfully, those are all argued. You're asking a merits-based question, and the derivative argument doesn't answer the merits-based question, which I'll get to in just a minute. but all of those claims, all of those elements were used in their common law claims just as well. It's all there. The derivative claim simply asks, is the 93A claim essentially the same, materially the same as the underlying claim that failed? The answer is yes, and the derivative argument applies, and the court should reverse. Let me turn now to the second argument here, which is the
Before you do that, you rely on Gossels for that?
yes, we do, Your Honor.
And do you have any other case?
There are many other cases, Bruno versus Bruno, Commonwealth versus Tremblay, but the key case is Gossels, I would say. And if I might, Your Honor, have this chance, I see my time is already moving on.
Sure.
In Fleet versus Gossels, this is a very important case. And the point of Fleet versus Gossels is that an appellate court should police against arbitrary and gratuitous 93A awards, especially where the facts are complex, where the law is complex, and where there is a very sympathetic plaintiff. And the Cold Spring Green says Fleet versus Gossels doesn't say that, doesn't do that, doesn't hold that. Well, I have a slight advantage on them, which is I was counsel to Fleet Bank at the trial level and the appellate court level. And that's exactly what the court did do. And the court said what it was going to do and did in footnote number 9. It says, when a trial court does not make a specific finding, an appellate court may consider stipulated facts, documentary facts, and facts that are not contested and clearly established in the record. It may also make additional findings that are not in conflict with the judge's permissible findings. That's footnote number 9. That's what they did. What the court then did was it policed the record in the case, including the appeals court decision, and concluded that the appeals court decision was not supported by the documentary facts, was contrary to the evidence, or was unsupported by the evidence, and found facts that the appeals court had not found and reversed. What it did in reversing was didn't just uphold the trial court ruling, which was there was no 93A violation. It found the facts and then concluded there was no unfair or deceptive conduct at 93A should be reversed. Now, looking at the merits, 4 points. As to the merits, there are loan documents. As to the loan documents, the documents contained a cap on lending amount, which is 3.9 million. And also, there's no promise in those loan documents of a phase 2, nothing there. There is, secondly, a commitment letter. And that commitment letter says that the bank may require a satisfactory appraisal before additional lending. Now, that cap is important because the cap of 3.9 million takes into account something called the loan to value ratio that the bank does not want to exceed. And I won't go into details on that right now because I don't have the time, but there's a reason why that cap is there. It's not arbitrary. It's a hard number, 3,933,000. They can't go beyond it. In phase 2, which is over 900,000, they must exceed the cap. So with respect to the contract documents, there's a cap and there's no promise. With respect to the commitment letter, it says a satisfactory appraisal may be required before additional lending. There's no promise. It may be required before additional lending, no promise. Finally, next there's the loan documents, the loan modifications. The loan modifications all reiterate the prior documents, reiterate them, and again, by reiterating them, they state the cap. They state the cap, and they make no promise of further lending. It's not there. Finally, there is the statement that the bank engaged in misrepresentation because a loan officer said, her name was Krista Berardi, said that we will roll into phase 2. We will roll into phase 2. However, subsequent to her statement saying that, which was March of 2009, what then happens is there are 4 loan modification agreements after that, from the time period of June 2009 to June 2011, which reiterate and say no waiver, signed. These are all signed by the borrowers, reiterate the loan documents and the commitment letter where there is no promise and there is a cap. There's a cap. So all of their claims fail on the merits. They fail on the merits. And what do they say to get around this?
I'm sorry, let me interrupt you. I'm sorry to interrupt. On the Rule 52 issue, two questions. One, did you ever ask for findings or express dissatisfaction with the judge's findings? And two, do you have to?
I didn't hear the second part.
Well, let's answer the first one. Did you ever at the trial level say that these aren't sufficient findings? You didn't make clear enough findings, Judge?
But we don't have to, because what happens under Rule 52?
No, so the first question was, that was the second question. The first question was, did you?
No, we did not.
Okay.
Because
And you don't
we
have to
relied
do
upon
that.
the rule.
Okay, and I just wanted to get, so, and you did not be, you say you don't have to because,
The rule says so. We don't, the rule says quite clearly that we don't have to make a, in order for the requirement of the judge to find the facts, especially under Rule 52, the rule says right clearly right there that we don't have to object or file a motion to amend or to alter. That objection is preserved for appellate purposes by the nature of Rule 52 itself. So my second argument, which let me finish on before I go.
Well, I'm
directly-
afraid your time is up. And your arguments are spelled out in your brief, but I am going to check with the panel to see if they have any further questions for you.
I have one additional question.
Okay, please go ahead.
So, was the bank aware that the doctor believed further lending was coming in the phase 2 portion of the project, notwithstanding the bank's belief that they had committed to no further lending? Do you understand that question?
Well, I think I do, which is we had never told him that there would be phase 2 funding. We never promised that. There was the
I
cap.
understand that. But I'm saying, notwithstanding that, the doctor, for whatever reason, right or wrong, was under the impression that further lending was coming in phase 2. And was the bank aware of that? Did they exploit that, what you may call an improper belief?
No, the bank did not do that. The bank told him otherwise, and he knew otherwise. He testified at one point, and I can provide the exact citation. He testified that the bank officers told him, and I believe it's at volume 1, section 551, page 551. He testified that he understood from what the bank officers said, if you sell down phase 1, we'll roll into phase 2. You sell down phase 1, we'll roll into phase 2. That's what he testified to. So he didn't even believe that. If he sold down, sure, there's a good chance the bank will do phase 2, but he never did. So he didn't even believe that, whatever rhetorically they may say. Volume 1, 551, I believe it is.
Thank you.
So the answer to that question is no.
All right, so thank you for that. Justice Desmond, do you have any follow-up questions?
No, thank you.
Okay, all right, and Justice Massing, you finished your questions? Thank you very much, Attorney Gillerin. Thank you. Now we'll turn to Attorney Harding.
Good morning, Your Honors. John Harding for Dr. Ashkuri and Cold Spring Green, LLC. The judgment in this case should be affirmed in all respects, except we should also be awarded our attorney's fees and costs on the appeal that we've been involved in for some 15 months. I have an advantage over Mr. Gillerin because I was at the trial and tried the case along with my partner, Ken Walton. Attorney Gillerin was not involved until the case went on appeal. This was back in the old days when we had jury trials, and we had a jury trial that lasted some 8 days. The court and the jury heard 9 witnesses, and at the conclusion of that process, the jury found, after being carefully instructed by Judge Pierce, that there was a 93A violation. They further found that that violation was knowing or willful, and they awarded the $1,040,000 in damages to Dr. Ashkuri. There were a lot of other damages claimed. That was the number they picked.
do you have a speculation of how they picked that number?
No, we do not have a stipulation of it.
A speculation. Do you have a guess what that number represents?
Certainly, it's fairly close to the amount of the phase 2 funding that was not awarded. There was also evidence that some of the additional collateral that Dr. Ashkuri lost in terms of office condominiums that he owned in Newton on Washington Street, principally where his longstanding architectural business, Arcad, was located. Those had been pledged along with the properties that were being developed. And there was evidence of an appraisal of the office condominium that was in that range. So that is another point. And of course, the bank has never contested in any respect the damages award. They've not said that it was, not well founded. There was a range of options that the jury was presented with, and so there's been no challenge to the damage award.
The amount that you requested, you didn't get all that you requested. How much did you request?
The total was in the 17 or so million range, because we had not only all the loss of the property, the loss of everything that he had paid. The value of these properties had increased significantly during the period of the project. And so just the hard costs of the property losses was some $5.5 to $6 million. Then there were also claims of the impacts on his business and other losses. So then we had post-trial briefing on 93A. This so-called derivative rule, which I'm happy to address, was never raised with the judge below. That was invented solely on appeal. They never challenged anything other than saying that basically the conduct alleged did not rise to the level of a 93A. The judge, having heard all the evidence over 8 days, as well as the exhibits, concluded that yes, indeed, there was a 93A violation. It was knowing or willful, doubled the damages, and awarded fees. And as
didn't they also, just a question, didn't they also say in their post verdict briefing that since the jury had returned verdicts in their favor, that the no 93A claim could lie? And isn't that sort of the same thing as the derivative rule, maybe without saying it exactly?
Well, I think it wasn't made clear, but in any event, I'd like to address this derivative issue. I think what Justice Desmond said earlier, that we are talking about a cumulative course of conduct by the bank outside the four corners of the documents that gives rise to the 93A liability. That course of conduct started with, at the very initial stage, the loan officer. First of all, she wrote an internal memorandum that made it clear that this was to be a single project with two phases of funding. The first being the $3.9 million, the second being the $910,000. She made it clear in the internal bank credit memorandum that without funding both phases of this project, there was no way it could ever be repaid. So the bank knew from the outset they had to do both phases. This same loan officer, and she was a former employee, but she came and testified live at trial, that the condition to what she referred to as rolling into phase two, and that was a key concept that my client understood, the rolling into phase two, was that the bank obtain an appraisal at some point in the project showing that the project had held its value. It was not conditioned on sales of these, and these are two buildings with a total of 4 units, very unique. If your honors have had a chance to look at the pictures of all of this project, it's not just some routine condominium project. Dr. Ashkuri is a world-renowned architect who designed the Ellison building down at Mass General. And so the key concept was that they would roll into the phase two funding, and to do that, they needed an appraisal.
I'm sorry, I'm going to ask you about that. In your
Sure.
brief, you say on page 18 that the credit memo confirmed that the bank intended to roll into the phase two funding. And then I don't, where in that document did the bank agree to roll into phase two funding?
That was I think if it said the credit memo, it should have said the letter of commitment, because we have an actual quote from it. And that's where they say that the bank reserves its right to require an adequate appraisal or a satisfactory appraisal, I believe is the exact language, before rolling into phase two. And Krista Berardi testified at length, Dr. Ashkuri testified at length that that was the deal. So in the middle of 2009, while the bank was floundering, in fact, failing and about to be taken over, except for the fact that it was able to negotiate a merger to become part of East Boston Savings Bank. The bank got that appraisal. It showed not only had this project held its value, but in fact, it had increased in value by some $1.5 or $1.6 million. So what Mr. Gillerin is saying about loan to value, it just doesn't apply here. But the bank did not disclose that appraisal to Dr. Ishkuri at that time. And even later, when he found out about it, they didn't disclose it. That in itself.
In your brief, you say that the letter of commitment said that they were obligated to give him a copy of the appraisal. I don't see that in there either.
It's definitely in there. I don't have it right in front of me, but
I actually can take a look at it though. It's Appendix Volume 2, page 183. You say in your brief that it clearly obligated the bank to provide him with a copy of the appraisals. I want to see
upon request.
Actually, that's not what you say, but if it says that in the if it says that, see where it says upon request, he can have the appraisal.
Right. But in any event, that was the condition.
So is it no? Where is it?
I don't think I'm going to be able to pull it up.
All right. But you say if I look really close through Exhibit 14 there, which is called
13 and 14.
That I will find something that says upon request. I mean, I see where it says a satisfactorily updated appraisal may be required by the bank before additional funding for phase 2 interior fit up. But I don't see where it says that they have to give it to him or that he can request it. But you say if I look really closely, I'll find that?
Yes.
Okay.
I mean, we didn't, that was always, and there was no contest on that. And Ms. Pergolo, who later took over for the bank, didn't dispute that when she testified. She just said, we're not giving it to you. But the bottom line is that this shows that the bank knew that the trigger for the rolling into phase 2 had happened, didn't disclose it to Dr. Ishkuri, and then kept asking for more and more collateral, which it did not need because the value of the project was greatly in excess of the amount that had been lent. So that is certainly one aspect of the unfairness. And I think in terms of cases, if your honors look at the Renovator Supply case, it's almost a direct parallel where Renovator Supply was in a lending arrangement with a bank, and the bank kept changing the terms, altering things. And it goes also to the concept of the derivative rule, even though it's not discussed there, because their Renovator Supply did not prevail on a breach of contract theory. They did not prevail on, to the extent it could be considered a separate cause of action, an implied covenant of good faith and fair dealing theory. But nevertheless, the court there sustained that the overall course of dealing and the way that they were treated constituted an unfair and deceptive act or practice. It's also particularly significant because the court pointed out that the unfairness doesn't have to succeed. In other words, the person who's the target of it can say no, as Renovator Supply said, no, we're not agreeing to those terms. And here, Dr. Ishkuri at the end, before the bank pulled the plug on this, was asked to pledge his home as collateral for this project. He said no, the bank pulled the plug, put the project into default, and the whole thing went into foreclosure, both the project and his office condominiums. And in Renovator Supply, they made the point clear that the fact that the bank made inappropriate demands of its customers was sufficient to state a 93A, even though the customer at the end of the day had walked away from the deal. On this derivative claim point, I think the thing is that the Park Drive case and the North Side recycling case that are relied upon by the bank, they are cases where ultimately there was a finding that there was no contract at all between the parties. And so, yes, in that circumstance where there wasn't even a base contract that could be the subject of a claim. So that is hardly some derivative rule. And I think we established clearly at trial that our claims for 93A were separate and outside the four corners of the agreement. The other point on Gossels and Tremblay is that Mr. Gillerin has only read you part of the footnote and part of the statement in Tremblay. And both of those cases make it very clear that what's stated there does not overturn the clearly erroneous standard of review. And that when both in footnote 9 in Gossels and then in the later Tremblay case, it's in the text, they make it clear that when findings are based either wholly or partly on live witness testimony, then there is no basis for the appellate court to go to the record and say, we're going to find a different set of facts, even though we didn't hear the witnesses. That's left out of their quote of Gossels and Tremblay, but it's a critical point. It really does explain how, to the extent that there's a difference between the interpretation of 52A under Massachusetts law and the federal counterpart, that if you're dealing with witness testimony, it's just a different set of facts. And so what we've
let me interrupt you just a second, because I think we had a little bit of a loop problem with the timer here.
Okay.
The way, I think I caught it at the first loop, yes. And I was going to say that I think you have about 15 seconds left, and maybe it is actually that your time is expired. It was cutting down to about 1.5 minutes when it looped back to earlier. So your time is expired. And I'm sorry for the interruption. And I know that if you would like to sum up, I don't want to put you on edge because the clock was not really following through.
Sure. Well, I'm happy, first of all, if there are any questions on any of the points the bank has raised. The one I didn't get to is the 52A, which, again, they never requested any specific findings of fact. And 52A, the one point which I could not pin down in Massachusetts law, is the rule starts with in actions tried without a jury. Well, this action was tried with a jury, and the jury made.
I actually was going to just ask if you needed to sum up on anything, not to start a new argument, which is sure. Not now that we're there. But let me double check with the panel to see if they have any additional questions. So Justice Massing or Justice Desmond, any follow-ups?
I have one other question. So looking at the letter of commitment, was there only one appraisal report throughout this whole project?
Well, there was an initial appraisal at the start, so that before the bank ever lent any money, it had appraisals done of what what the value was of these condominiums, you know, if they were to be developed. That was back in 2007. And then
excuse me for interrupting you. So when I read the language that says you have the right to a copy of the appraisal report used in connection with your application for credit, and if you wish a copy, please write, and you have to hear from you within 90 days and we'll send it out. That's not talking about the appraisal with respect to phase 2.
Well, it wasn't. First of all, that's the only document. So that language that Your Honor just read is the language that I was struggling to find, but it continued throughout the whole project, because as Mr. Gillerin pointed out, any of these loan modifications reverted back and incorporated the original documentation, including the original application that had that provision. So there wasn't something new that was entered into when you got to the time of the later appraisals. And so that's exactly the language that's relevant here.
Thank you.
All right. As I see no further questions, I want to thank you both very much for your arguments. They're very helpful, and we'll
We are live.
Okay, thank you very much and good morning. Welcome to today's remote sitting of the Appeals Court. My name is Ariane Vuono, and I'm joined today by Justice Gregory Massing and Justice Kenneth Desmond. Just a quick reminder, you each have 15 minutes to present your argument and there is no rebuttal. I won't jinx us by saying anything more about technical difficulties. We've had a few today, but so far so good. We're here now, and we do thank you for your patience. So let me call this case Matthew Haney and another versus the Department of Environmental Protection and others, 2019-1395. Attorney Revere, please begin your argument.
Thank you, Your Honor, and members of the panel. Paul Revere on behalf of Matthew Haney in both matters as trustees. This is an appeal of a decision of the Department of Environmental Protection. I've done a few of these in my life, and generally, in most cases, I would tell my client, it's so deferential, it's not worth the time. When I look at this case, Your Honor, members of the panel, this is a case which is ripe for review and is one where the DEP's decision should be reversed. The primary issue is it's the application of something known as the plan changes policy. That's a policy where DEP can accept changes from the applicant. Now, the interesting thing about this case is not only does it have the plan changes policy and the failure of the DEP to properly apply it consistent with its rules, but it also overlaps with a decision of the Supreme Judicial Court called Oyster Creek Preservation. In the Oyster Creek Preservation case, the Supreme Judicial Court held that when a conservation commission does not act in a timely manner on an application under the Wetlands Protection Act and a local wetlands protection bylaw, that it loses the local conservation commission the ability to apply the local bylaw and to make the decision in the first instance. Now, in this matter, the Mashpee Conservation Commission failed to act in a timely basis on a proposed timber bridge. That timber bridge, that failure to act was appealed by my clients to the Department of Environmental Protection's Southeast Regional Office. The Southeast Regional Office actually denied the timber bridge.
Mr. Rivera, I'm sorry, I'm gonna interrupt you. We have a short time and we know the facts.
Okay.
Let me ask you get right into something. On the plan change policy, I don't understand you to be arguing in your brief that the change from timber to steel was insubstantial. You're not arguing it's insubstantial, is that correct? You're arguing that it's substantial, but they can disregard that.
I think primarily we're not arguing because you have so much deference to the factual determinations of the DEP. So we're arguing, yes, it is substantial. And therefore, the first step of the plan changes policy is whether it falls within one of the three exceptions.
And you say it falls within the first exception because the failure to act.
Correct.
But wouldn't you agree that if that exception gives the department, it says may, that it gives them a discretionary decision whether to accept the change or not?
Right. It gives it discretion. I agree with that, except if you read the language, and I can give you specific citations to the appendix, the administrative law judge says, I have it written right here, it says, he concludes, it's appendix 7, page 657, says, petition's proposed steel bridge alternative is substantially different from the original proposed timber bridge and increases wetlands impacts to the salt marsh and land containing shellfish. As a result, the petitioner's revised project cannot be reviewed and approved in this appeal. Okay.
Your
But
point is
must
that
be submitted. Okay. There was no application of discretion. The administrative law judge said, I cannot review and approve it. And that's not applying the policy. The policy is to do discretion. And it also overlays with the Oyster River decision that basically the Mashpee Conservation Commission had no authority to act further in this matter. And
So
that
is
was-
your point that the administrative judge did not understand the fact that he had the discretion? Is that the point?
I'm not reading the administrative law judge's mind. I'm reading what he wrote in his words, and he said, the petitioners cannot be reviewed. Okay.
So would you like us to remand it to the administrative law judge so we can say, oh, you if you like to, you may, and then what's he going to do?
Well, it's an interesting point too, because there are a number of issues here, and that's why I bring up the secondary point of Oyster Creek preservation. As I see it, Oyster Creek preservation places the full authority to decide the Wetlands Protection Act in the hands of the DEP. And in fact, I note when I say the DEP, what's quite interesting here, and I can give you the citations again to it, volume 6, page 148, and volume 6, page 157, the DEP Southeastern Region's position was in this litigation that not only could the plan changes policy apply, but the steel bridge was approvable.
Of course, that's not binding. Of course, that's not binding though, right?
Oh, I agree. And in fact, that leads sort of to the secondary issue, which is a lesser of importance, is the burden of proof, how my client keeps getting put the burden of proof on them that they need to prove substantiality, and prove that the plan changes policy ought to apply. And yet at the same time, they were taking with what was the department's position in this matter. So when I look at it, to me, I think when you say it should be remanded, I think it should be remanded for purposes of giving a reason for their discretion. The reason right now is not supportable. And note, under the Masiosi case, which is cited in my brother's brief, who wrote the brief, I'm now appearing for oral argument, they have to actually apply their policy, but it should be remanded to apply their policy and explain why, in light of Oyster Creek, it still should be remanded. I note that too. The plan changes policy was made in 1991. It was revised in 1995. Even at that time, it recognizes being able to move forward with changes, probably based on the Citizens for Responsible Development v. Attleboro case, where changes are allowed to happen. But the plan changes policy has never been revised after Oyster Creek, wherein, using the language of the Wetlands Protection Act, the Supreme Judicial Court said that the sole determining authority to act is in the DEP when the commission fails to act within 21 days. So
but wouldn't that be failure to act on the original proposal, the original NOI with the timber bridge? The Conservation Commission was never given an opportunity to act on the steel bridge.
Well, yeah. And, and then you come to this issue of defining, of course, and the plan changes policy looks at this too. It recognizes, uses specific language of that revisions, I'm reaching over to here. That's always so fun to find these things. Revisions can include changes to roadway alignment, drainage structures, and multiple things. And this is a bridge. I don't know how you put it. It's a bridge from point A to point B. It moves from the end of Punkhorn Point Road to the island. This is not like the, Cave case in Attleboro, which involved both a roadway and a single family home. A bridge is a bridge. It goes from point A to point B. The impact.
So just to be clear, is the answer to Justice Masson's question yes, that the DEP has never had a chance to review this particular plan, the steel bridge?
The DEP, okay, in the Southeast Regional Office, after the appeal was filed, changed its position from denial of the timber bridge to approval of the steel bridge, the DEP Southeastern Region. I want to make that clear so we don't get them confused. and said it should be approvable under the plan changes policy. The administrative law judge concluded that it had substantial impacts and cannot be reviewed and had to go back without looking at the issues of discretion in the matter. And I think.
Is it true that in the post-hearing brief, you included 19 or 20 different, I'm going to call them mitigators, with respect to the impact on the marshal? And those mitigators, those were never vetted by the folks who were in opposition to the project. Is that fair to say?
Well, I don't think that's fair to say. I mean, those are potential. What I think you're referring to is the potential conditions that ought to be added.
Mm-hmm.
That they sought out and determined to add. I mean, yes.
Yes. But remember, those were in the administrative record. And one of the things that's in the brief here, and I know when you say you, referring to, of course, my client, since I came into this case later, the matter, one of the arguments my clients made was that it should have been remanded to be conditioned, or should have been conditioned by the administrative law judge, not sent back all the way back to the Mashpee Conservation Commission, because they had waived their right in the matter. I mean, one of the things that Citizens for Responsible Development, the Attleboro, talks about is the plan changes policy is an attempt to make, also to have efficiency, not to have a matter get sent all the way back down only to get appealed back to DEP.
Doesn't the policy say something that they can consider it when appropriate? Isn't there some other language in there that says it's not that they must, but they have to make a decision about whether to consider it or not?
Correct. There's no question that the terms of the policy provide, say, may review the policy under these three circumstances. And we're talking about circumstance number one, the failure to act of the Conservation Commission. But here, as I pointed out in the beginning of my argument, the administrative law judge said they cannot review it, did not make a discretionary decision, and did not did not explain the rationale for exercising the discretion. It's a classic judicial issue, the issue of unreviewable discretion. If there isn't a reason explained, then a decision becomes unreviewable. An interesting point too, of course, is that in agency law, generally, the appeals court only affirms a decision based on the grounds adopted by the actual agency. As it says in NSTAR Electric, the Department of Public Utilities, 462 Mass 381, the agency's ground for decision must be clear from its order and not from post hoc rationalizations. And it's actually, technically, it says appellant counsel's post hoc rationalizations, but I didn't want to make any aversions to my fellow counsel in this matter.
So in terms of that, a couple of questions. So if you read the ALJ's decision, it's pretty clear that the basis for the decision is there's 5 experts, and he credits the experts that are that oppose your client, and he discredits the experts that your client presents, right? I mean, so it's pretty clear. It seems pretty clear what the basis for the decision is, wherever you put the burden of proof. So if the only thing that this is just speaking for myself, and I'm not saying what the panelists would do. If the only thing we agree with you is that the ALJ had discretion, but wrongly said, I don't have any discretion. If we remand it for the ALJ to decide whether or not to exercise that discretion, would you rather us do that, or would you rather us just remand the whole thing back so you can start over?
Well, I think there are 2 parts to that, because the first decision is whether he credits the experts. He doesn't, not only is it my client's experts, he does not credit the DEP's experts, but what he says is that there are substantial impacts. He doesn't say that they're not impacts that can't be permitted. Okay, he doesn't, I mean, there's a difference. Whenever you do any action in a wetland, you have some amount of impacts on wetlands. The question is whether those impacts can be conditioned or not to meet the performance standards of the act. And the judge didn't make that decision. So I would say there are two pieces, both the discretion issue and two, it should have at least gone to the Southeast region to make a decision whether they could have permitted it. That's all.
So then the answer to my question was you'd rather throw your dice with a rehearing in front of the ALJ as opposed to starting from scratch.
I think it should go back to the ALJ for a decision to either to move forward or to remand to the regional office. Thank you.
One more question for you. You say on page 35 of your brief that the OADR, the ALJ, applied the incorrect burden of proof. What is the correct burden of proof?
Well, the correct burden of proof, I laughed when I was looking at this yesterday. The burden of proof applies to the person opposing the department's position, and it's the department's position essentially at the time of administrative trial. I actually had a case where my client got a superseding order, the Cordy Allen case, and then the department decided it didn't like its superseding order in a couple months before the adjudicatory hearing, and therefore we carried the burden of proof. Ultimately, the burden of proof, I agree, of demonstrating compliance with the Wetlands Protection Act is always on the applicant, but the burden of going forward, which is really what was cited in this matter, in the administrative proceeding, should have been placed on the people going against the department's position.
Okay.
Okay, I don't have any more questions.
Okay, thank you, Justice Massing. And how about Justice Desmond? Any follow-up from you?
Nothing additionally, thank you.
Okay, thank you. Nothing from me either. So thank you, Attorney Rivera, for your argument, and I will turn to Attorney Triplett.
May it please the court, Tracy Triplett on behalf of the Department of Environmental Protection. I just want to touch briefly first on this idea that the presiding officer and by reflection, the commissioner who actually issues the final decision, it's just a recommended final decision from the presiding officer, are somehow unaware of the terms of their own policy and that there are exceptions in that policy. I don't think there's any basis to make that assumption here. I think, in fact, what is on the record is that the trust never properly made this issue of an exception an issue in the adjudicatory proceeding. The department's regulations require the presiding officer to prepare and share what's called a statement of issues to be decided at a hearing before the hearing begins. And they prohibit the presiding officer from allowing a party to, absent a showing of good cause, add a new issue later. And those regulations are cited in our brief, but they're at 310 CMR 10.05 and also 310 CMR 1.0116K. And the point of those rules is to promote efficiency and fairness and prevent a situation like, frankly, what happened here, where a party waits to the last minute to inject a new issue into the case. And here, the only issue that the trust asked the department to determine was whether their new steel bridge proposal was an insubstantial change under the policy. And consistent with that request, the presiding officer identified the issue related to the policy to be decided as whether the project changes made that new project substantially different from the original project. And no one, including the trust, objected to that being the issue to be decided. And so that's the issue the parties litigated. And that's the issue the presiding officer evaluated and on which he made very specific and detailed findings. As we've heard, the trusts aren't appealing, I guess, this determination of substantialness, which relies on those findings. And that's not surprising because the department found that the trust had presented no credible evidence to refute the other party's expert testimony, including testimony that this new proposal, this new steel bridge, would be larger and significantly heavier than the original timber bridge. And that as a result, in order to construct it, you would need to mount a crane on a barge, and that bringing a crane-mounted barge into a shallow intertidal area created a real risk of harm to these protected shellfish areas in that location. And also that this heavier bridge had large concrete abutments that would detrimentally affect the salt marsh. So,
I'm sorry, Attorney Triplett, I just want to back you up a little bit on the failure to raise the issue at the hearing. It's raised after the hearing in a post-hearing memo, right? Before the presiding officer issues the opinion.
It is. And under the department's regulations, if you want to raise a new issue that late in the game, you have to demonstrate good cause. And that is not demonstrated in that post-hearing brief. It's a very bare bones argument saying, what about this exception, basically? There was no good cause demonstrated whatsoever. There was no effort to make that. You know, in addition, the final decision comes down and the trust don't even ask for reconsideration. If this was such an important and significant issue to them, they had the option to do that rather than getting us all to this point. But here we are. So, and some, I think, you know, just on this, this point is that the department fully and fairly resolved the issue related to the policy that the trusts and all the parties agreed to have it decide. And that was whether this new project was substantially different from the original project. And they're not challenging that determination here, as you've heard. And on that reason alone, I think the court can affirm. And to do otherwise would not only be extremely inefficient, it would be really unfair to the parties who spent time and resources litigating an agreed to set of issues consistent with the rules for these hearings that everyone's aware of, that the department has promulgated. And it would also set aside a determination that is entirely consistent with the legislature's clear policy judgment that projects affecting wetland resources should be reviewed at the local level first. This court's recognized that principle, that legislative intent, several times in its cases, including the Hamilton case that's cited in our brief. And that policy is expressly reflected in the department's plan change policy, which says that the primary purpose is to have these types of, to have local review first of projects affecting wetland resources. I'm not quoting, I'm paraphrasing there, but that is the express purpose. And here,
although both Oyster Creek and the plan change policy recognize that the Conservation Commission sort of gives up some of that ability when it fails to act or fails to timely act.
Absolutely, Your Honor, it does. When that happens, the department has superseding review, and under its plan change policy, it does have the discretion to keep, a project for review first, but that's not the default. That's not what the statute and the legislature's policy judgment is as a priority. The priority is, the whole focus of this system is local review first. And I mean, we're not talking about the same project that apparently, inadvertently in this case, the Conservation Commission didn't timely decide on. I mean, it spent a lot of time, the record shows, reviewing that original project, but there was a mistake at the end and they missed the deadline for when they needed to issue their determination. They spent a lot of resources deciding it, and then they've been litigating since, right, as part of these proceedings.
I wanted to ask you about that as well. In the plan change policy, the exception for when there's a failure to act. Setting aside the timeliness of raising it, would the late action qualify as a failure to act within the meaning of the plan change policy?
It arguably would. The department didn't make a clear decision on this. It is an arguably applicable exception. Okay. Having said that, as you've noted, the policy is extremely permissive when it comes to applying those exceptions, as you would expect, because we want local review first. It should be a really unusual situation where the department keeps it. So as a technical matter, perhaps this situation meets that exception. But in terms of what those exceptions are generally getting at, and there are 3 of them, they're focused on situations where the Conservation Commission really explicitly is waiving, right? Waiving its local review rights, is not interested in the project. The third exception allows, through consultation with DEP, for the Conservation Commission to say, okay, you know what, department, why don't you handle this in the first instance? We're fine with that. So all three of those exceptions are really about a situation where a Conservation Commission doesn't want to have the local review, is evidenced one way or another. And that clearly isn't the case here. And so the department, it really probably wouldn't be, although the department has a lot of discretion, it wouldn't be the best case probably to exercise its discretion to keep a project by exercising the exception.
Can I ask you a question about the burden of proof? In your brief, page 33, you say that the other side ignores the qualifying language that follows the person contesting clause. And so you quote, the burden attaches to the quote, person contesting the department's position, then you italicize, when the department has been requested to hold an evidentiary hearing. What is the significance of that language and why do you italicize it? I don't quite understand the argument.
Yes, Aaron, I'd be happy to explain. So the department interprets that language as indicating at the time an appeal is filed, when the appeal is filed, the person who's contesting the department's position at that time has the burden of going forward. So it attaches to that person. It might be a project proponent, it could be a resident or someone else. I think the interpretation that the trusts are taking here is that it might switch over time. It could be that the person who was originally contesting, as in this case, is not contesting the department's position, at least the region's position, the staff's position, and so the burden should flip. That's not the interpretation that the agency takes of its own regulation. And I think, what's also important to point out here is that the policy, which is the directly, most applicable document here in setting the burden, specifically provides in its last paragraph that the burden of proving that a change is insubstantial is on the project proponent. So I think that's really the, that document probably controls. To the extent there's any ambiguity in this 310.10.032 regulation, the department has a rational interpretation of it, and that should control. And then I would note, and I think what's maybe the sort of primary thing on burden of proof is that the presiding officer found that the trust had failed to present really any credible, unrefuted evidence to support their position. And so whoever had the burden of going forward, it wouldn't matter for them. They wouldn't succeed in either case because of the findings that the presiding officer made on the evidence presented. The other issue I wanted to touch on that has come up here is this issue of whether an express finding is required on whether the exception is being applied. And consistent with the legislature's policy judgment, the policy here on local review first generally does require that you send things back to the Conservation Commission first. And I think that makes sense because you have a project that is either significantly changed in its configuration or having increased environmental impact. It's akin to having a new project with greater impact. So it makes sense that the policy is focused to send those type of projects back for local review first. So because of that, really the department isn't required to make an express finding that no exception applies when it is declining to review a substantial plan change. And that's because under those circumstances, local review first, that legislative prerogative, is exactly the result contemplated by the policy. And this is really reflected in the language of the policy. It's very permissive. There's no requirement to make an express finding anywhere in that policy. The department may accept a project if it decides to exercise its discretion to apply one of the exceptions, but it doesn't require the department even to take a look to see if an exception applies, much less apply one if there is one that's applicable. And that makes sense, again, because local review is really the overarching goal here. The other thing I would point out is that in this particular case, applying this failure to act exception would have been really inappropriate. And that's because, A, as we've discussed, there were significant wetlands impacts found by the presiding officer. And those were similar to the ones that were of concern to the Conservation Commission when it looked at the original project. So the Conservation Commission is concerned about these type of impacts. And also, as I noted, this appears to be a situation of inadvertently missing the deadline. So given those undisputed impacts and that the Conservation Commission was clearly concerned about them, it was really appropriate for the department here not to apply an exception.
Can I just ask you another just procedural thing? If they had to start again with a new notice of intent on the steel bridge to the Conservation Commission, and should the Conservation Commission reject it, there's still an appeal to DEP where they can appeal the Conservation Commission's application of the Wetlands Act, but the CC has sort of the last word in terms of the things on its bylaw that are special to Mashpee.
You're right, Your Honor. The Mashpee does have its own wetlands bylaw with some more stringent provisions consistent with the act, which is what's required. If there was a dispute over if the Conservation Commission denied the revised project when it went back down again based on the bylaws, that wouldn't be something that would come to DEP. It would be handled through if there was a dispute over it, a separate Superior Court litigation. I don't know, and I think there isn't enough information about this new project. Like, one of the reasons that the presiding officer was concerned about is there just wasn't sufficient information really about, they didn't know how they were going to construct it. So the other experts said you're going to need to do it this way. Those mitigating conditions that came in really late, so they weren't allowed to be part of the record. Well, perhaps they would address some of these concerns. I don't know, it's not in the record how that would work, but I do want to put out there, I don't think it's like a foregone conclusion that the Conservation Commission couldn't or wouldn't approve this new project. That's for them to decide. No one's saying the trust can't proceed with this project or at least put a new application in. They absolutely can. They just need to do it first through the Conservation Commission, which is really that local review first approach that the statute and the legislature have set up. I see that my time is up.
Yep, your time has expired. So we thank you for your argument. I'm just going to double check with the panel to see if they have any follow-up questions for you. So none from Justice Massing, and I see none from Justice Desmond. I don't have any. Thank you both very much for your argument. We can tell you that we've gone through the entire record, so we're familiar with the record and familiar with the facts. So you can just get right to what your legal points are at this time. Okay, so you may begin right now.
May it please the court, my name is Adrienne McGlone, the appellant in today's case. This case raises issues of whether the appellant, Adrienne McGlone, can be legally and lawfully found in contempt of court without any violations of any order or contemptuous acts. The appellant in this case was in no violation of any order. In fact, the appellant, Adrienne McGlone, provided evidence such as phone records, text messages, and written documentation of compliance to all orders, as well as submitting evidence that gave proof that the appellee, Joe Austin, did not follow the instructions of the May 30th, 2013 order. The May 30th, 2013 order clearly set out the stipulations to be followed. The appellee, Joe Austin, during trial, provided no evidence indicating he had complied with any portion of the May 30th, 2013 order. However, the appellant, Adrienne McGlone, provided evidence, again, such as phone records, text messages, and written documentation that proved that the appellee, Joe Austin, made no attempts to follow the May 30th, 2013 order or have a relationship with the minor child. This case
I'm going to
has.
interrupt you, Ms. McGlone. I'm going to interrupt you just for a second because I have a question for you. But before I pose the question, I apologize. I neglected to introduce myself and the members of the panel to you. So my name is ADRIENNE Vuono, and I'm joined today by Justice Gregory Massing and Justice Kenneth Desmond. So I apologize. When they speak to you, they'll introduce themselves as well, so you know who's talking with you. My question is whether or not about your familiarity with what was required of you with respect to the judgment that was issued and setting up a parenting schedule.
Yes, if you look at the record clearly stipulates what is to be done by who, and I was clear of my requirements to fulfill the order. So yes.
And what were those requirements?
I'm sorry, I didn't hear you.
What were those requirements in your view? Can you explain them to me?
According to the order, I was to allow any communication from the appellant, should there have been any.
Okay.
Not saying verbatim, because I don't actually have the order in front of me, and I don't want to move around too much because I don't want to lose you guys, but
okay.
The order was definitely very vague, but it did have some stipulations to be followed that were pretty much really simple stipulations.
Okay, and one of them, it's your recollection, was to allow for communication, correct?
Could you repeat that?
One of them, to your recollection, one of those stipulations to your recollection is to permit communication, correct?
Permit communication?
Yes, between your daughter and her father. Is that right?
No, I'm not sure that's consistent with the record. It doesn't specifically say anything about permitting communication. It was just a given that if there was an attempt to communicate, that communication would be allowed.
I see.
But the order doesn't specifically say that, nor does the order mention parenting time.
Okay.
Can I proceed?
Yes, you may.
This case has been a miscarriage of justice and replete with errors, such as the minor child ordered to unsupervised visitation with the appellee, Joe Austin, who has a criminal record of sexual assault and rape. The illegal removal of minor child from the home and placement into the Department of Children and Families custody for 120 days in violation of Mass General Law, Chapter 119, Section 29C, and in violation of minor child's right to an attorney and a guardian ad litem. Further errors were the continuous erroneous contempt, findings, fines, and confinement of the appellate Adrienne McGlone in an attempt to derail the appellate Adrienne McGlone's military career, which was in violation of the Service Members Civil Relief Act, formerly the Soldiers and Sailors Act.
Ms. McGlone, I'm going to interrupt you for a moment because I have a question. This is Judge Desmond speaking to you. One of the things that it seems you were found in contempt was because you did not allow father to have visitation with the child at reasonable times as agreed with mother. Did you ever agree with father about any times that the father could spend with the child?
As consistent with the order specifically is directed at the father in that instance, that he is to reach out to me with any times that he would want to visit or communicate with the child. However, there were no attempts from the fathers. So the order says that the father must communicate to me any time or try to come up with a time to do that. And the father never did that.
So there was never any agreement between you and the father as to when he was going to spend or visit any time with the child?
No, the father never reached out to me to set up any type of arrangements. And all the communication had been one-sided, had been me communicating with him. And in those instances, when I reached out to him, he never requested meeting with the child, say for any type of visitations or anything, as the record indicates.
And when you reached out to him, did you ever on your own agree that he could come see the child on any particular day or time or in any way?
I mean, I wouldn't be able to agree to anything if there was nothing suggested.
Okay.
So he never asked me, so I had nothing I could agree to.
Thank you.
The further errors were, excuse me, the ordering of contempt fines be paid from child support in violation of the 2009 Massachusetts Child Support Guidelines, which state child support is intended to meet the child's survival needs in the first instance. Money paid as child support is intended to be used for the care of the child involved. It's not for the custodial parent to use for expenses. In general, child support is designed to maintain a child's living standard and ensure all basic needs are covered. So basic needs such as shelter, food, clothing. And lastly, all actions taken in this case have been in violation of the Mass General Law, Chapter 231, Section 59H, special litigation against public participation, in which there has been malicious prosecution and intentional infliction of emotional distress against the appellant, Adrienne McGlone. And in conclusion, for all those reasons, the appellant, Adrienne McGlone, respectfully asks the court to reverse the trial court's judgment of contempt and order the appellee, Joe Austin, to join the appellant in application of passport for minor child and pay for the cost thereof.
All right. Have you concluded your argument, Ms. McClone?
Yes, I have, Your Honor.
Okay. I'm going to see if the panel has any questions of you before we conclude. Justice Massing or Justice Desmond, either one of you have any additional questions?
Okay.
I see none. Okay, I don't either. So thank you very much for your argument. What we do now is take the case under advisement, and we will issue a decision shortly. And